So let's start with this presentation concerning access to documents in recent case of the Court of Justice. And before going into details, let's just make a quick recap of applicable rules. I know you've been talking about Article 42 of Charter of the Fundamental Rights of the EU this morning. I will just like to remind you Article 15 of the Treaty on the Functioning of the European Union, which enshrines the principle of transparency and also the derogation from this principle, which covers Court of Justice, European Central Bank, and the European Investment Bank as far as the administrative tasks are concerned. But as you will see, the Court of Justice has shrinked a little bit the extent of this derogation in this case, in its case law, and it continued to do it this year. So the most important act concerning access to document is Regulation on Transparency, Regulation on Access to Documents, 1049 of 2001, and this act is intended to give a fullest possible effect to the right of public access to documents of institutions. That's actually the quotation from a case law. This fragment in red appears very often in rulings concerning this regulation. So what proves that this act is intended to give the fullest possible effect to the right of public access to documents is that Article 2 defines largely, I'd say, the notion of document held by an institution. Is not only, actually this regulation apply not only to the documents that were drawn up by the institution, but also those documents that were handed to, that were transferred to the institutions by other bodies, member state or other authorities or bodies. And second proof of this openness is the definition of document. It's a large definition. Document is actually any content, whatever its medium, concerning a matter relating to policies, activities, and decisions of the EU institutions. However, that right is nonetheless subject to certain limitations. This is also a quotation from the case law. So those limitations are set out in Article 4. This provision provides for a number of exceptions from the right to access to documents, and the structure of this provision shows that there are 3 levels of protection of certain interest. The first level of protection concern public interest, privacy, and integrity of individual, and whenever a requested document contain information concerning to this fields, then the disclosure of the document can be refused, and there's no possibility to somehow overturn this refusal. On the second level, we have different interests. We have commercial interests or of a natural legal person, including intellectual property, so the need of protection of commercial secrecy, the need for protection of court proceedings and legal advice, and the third interest that is protected by Article 4, Paragraph 2 is the purpose of inspection, investigation, notice. So whenever the document which is requested contain data or information concerning these 3 fields, the disclosure of the document can be refused unless there is an overriding public interest in the disclosure. So there is a possibility to give the access to the document, never in spite of the fact that certain interests which are protected by this provision can be undermined. And the third level of protection concerns the decision-making process. This is I'd say, the lowest level of protection. So the decision-making process is protected only when it could be seriously undermined. Then the institution can refuse an access to a document which was drawn up by it. So then we have to bear in mind this three paragraph of Article 4. Following paragraphs concern the approval of the member state and partial access to document, but I will actually, the case that I'm going to talk about today has not concerned this provision. So the access to document regulation is, of course, not the only one act that concern, on one hand, transparency, and on the other hand, protection of information. There are a plethora of other acts that can contain some provision concerning access to documents or protection of information, and both on the level of international law and EU law. And today, the case I'm going to present today gives us some insight into this act. It's Aarhus Convention, for instance, or TRIPS agreement, which provide for protection of intellectual property rights. And on the EU level, of course, the Aarhus Convention regulation, Regulation 1367 of 2006, on the application of provision of the Aarhus Convention to information, public participation, decision-making, and access to justice in environmental matters to community institutions and bodies. And of course, the Regulation 45 of 2001 concerning the protection of personal data. But there are also other acts that are applicable, and I would like to mention here the Directive of 2003, number 4, on public access to environmental information. And we were talking just like half an hour ago about harmonization. To some extent, I can say the access to document on the European level is harmonized, at least as far as access to environmental information is concerned. So let's go to the detail now. I was asked to talk to you, you could see it in the program, about cases concerning access to document relating to administrative or judicial proceedings, and I will start with it. That will be the biggest chunk of my presentation. I was also asked to talk about access to documents relating to decision-making process, and here I'm going to talk about two cases, Client Earth, which is right now pending, so I will be pretty short because it's a pending case. And the other case, it's Philip Morris. There are three rulings of the General Court which are actually more concerned about, but they concern more the protection of judicial proceedings and legal advice. Third, a group of decisions I'm going to talk about concern access to document containing environmental information. It's something that I decided to add on my own initiative, because I found very interesting developments in this field. And the fourth and the last part, and I hope I will be not too long with my presentation, will concern access to documents containing personal data. And here I would like to present you one Client Earth case. So as far as this first group of decision is concerned, while I was reviewing the case law, I realized that what is new in this case law concern the scope of application of the access to document regulation. So that was the question that can be answered, does the ADR apply? The second issue that was, the second question that was answered by the court and the General Court in this case law is, what does investigation mean? So does actually Article 4, paragraph 2 of the regulation applies? And the third question is, what is the scope of the general presumption of confidentiality? So does this general presumption apply? And this is a very strange animal. That's my personal view, this general presumption of confidentiality. So let's start with access to documents relating to judicial proceedings. Before I go into details of the actual developments, current developments, I'd like to just remind you one rule that was set out in the ruling of 2010, and Sweden should be thanked for this ruling. This rule that was spelled out in Sweden against API and Commission is that certain documents that are exchanged in the context of judicial proceedings, meaning written pleadings of the Commission, can be disclosed when the proceedings before the Court of Justice are finished. I'd say that this is the rule in the shortest, this is the shortest presentation of this rule. So in this case, the access to document concerned the written pleadings lodged by the Commission before the General Court and the Court of Justice in proceedings relating to certain landmark cases like Altmark and others, Airtours, and some of those cases were still pending when the access for document, the request for access document has been made. And in that case, the court actually shrinked for the first time the application of the derogation, or the derogation was not in Article 15 because Article but the Court of Justice has shrinked this exclusion that concerned itself in this ruling. And the Court of Justice followed this ruling in a decision of 18th of July 2017 in the Commission versus Breyer. So this case concerned a request of Mr. Breyer for access to documents related to infringement proceedings brought by the Commission against Austria and Germany. And in the end, actually, the most important document that was contentious was a submission lodged by, written submission lodged by Austria in proceedings in case C 18909. This is the case that was decided by 3 judges. That was a very simple proceeding that was very simple infringement case. So here the Commission refused the access to this document. It considered that it was not an addressee of this document, that it actually just received this document because it was a party to the proceedings, and that statutes of the Court of Justice do not allow for the disclosure of the written pleadings to other person than the parties to the proceedings. The General Court has annulled this decision on the basis of the violation of Article 2.3. So this is the provision that concerns the notion of document held by the institutions. And the General Court considered that documents held by the institutions are all the documents that are actually held by the institutions and that were received by those institutions in the exercise of its powers. So it concluded that the written submission were not covered by the derogation in Article set out in Article 15, Paragraph 3, Subparagraph 4 of the treaty. And there's another point, I think very interesting point, and very, I don't know, I would like to talk about it with you maybe later, or just raise this point briefly here. What the General Court did is something very unusual. It applied its provision of the concern. These are the provision of a procedural regulation concerning the costs of proceedings, where the normal rule is that whenever the applicant wins the proceedings, he doesn't have to, he or she doesn't have to pay the cost. It's the other party who has to bear all the cost of the applicant winning, of the winning party. So because Mr. Breyer won his case, he actually wouldn't be obliged to pay this cost. The cost should be borne by the Commission. But here, the General Court considered that this cost should be divided into 2, because Mr. Breyer published different documents that he has received from the Commission before. He published those documents on the website, so he shared this information with other people. And General Court applied kind of a sanction to Mr. Breyer for this. that's unusual. And I will not go further here, but maybe afterwards. And let's see what the Court of Justice did with this. Well, the Court of Justice confirmed the ruling of the General Court, including somehow, not the solution on the costs. First of all, the Court of Justice said that all the documents that are held by the institutions can be, should be covered by the notion, by the principle of the access to documents, and the fact that certain documents were filed first to the court does not mean that those documents are excluded from the right to the access when they get to another institution. And that's actually the confirmation of what was already said before in Sweden against API and Commission. And what is interesting here also, I think, is the way that the Court of Justice justified actually the exclusion of these documents from Article 15 of the treaty, because I think that the wording of Article 15, paragraph 3, subparagraph 4 of the treaty is very clear. But what the court said is actually is that the limitation of access to documents relating to court proceedings, whether they are provided for under Article 15 of the treaty or under access to document regulation, they pursue the same objective. And as far as protection of judicial proceedings are concerned, this objective is the protection of principle of equality of arms and the sound administration of justice. So as far as equality of arms and sound administration of justice are ensured under access to document regulation, then the objective of Article 15 is not compromised. So somehow the court find a leeway for justifying the exclusion of documents that were produced before the court in its judicial activities to find a to exclude them from the from Article 15. Oh, okay. So let's turn now to the access to documents relating to infringement proceedings under Article 258. And again, I will start with a little recap of the state of art here. And the state of art is LPN ruling of 2013, in which, for the first time, the Court of Justice applied the general presumption of confidentiality within the context of infringement proceedings. And in this ruling, the Court of Justice applied this general presumption of confidentiality to additional category of documents, meaning the documents in the file of the proceedings under of the infringement proceedings, but in the when these proceedings are still on the pre-litigation stage. And just two more words about this general presumption of confidentiality, and this is my personal view. I have to fight against. I mean, I have a real problem with this concept, because within the construction of the rule is that the transparency is the rule, and the exceptions from transparency are just exceptions. So whenever in those exceptions you try to push a presumption of confidentiality, which is general, then somehow this concept does not really find its place in the system of the regulation. However, I believe that this notion is just a form of or expression of some kind of compromise between different interests, and also a way of easing the life of the institutions, because in the beginning this general presumption of confidentiality was only applied to certain categories of documents when it was a set of documents. So there was a lot of documents. So instead of analyzing every document individually, the institution could just say, this is a category of document that should be protected, so we will just apply a general presumption of confidentiality. And this is how it started. However, as you will see today, this general presumption of confidentiality also applied to certain categories of documents which are built with 2 or 3 or 4 documents, so not really a set of documents. So as I said, in LPN, the Court of Justice has applied this general presumption of confidentiality to documents in the administrative file relating to an infringement procedure at the pre-litigation stage. And recently, the court went a little step further on this way. And this is the case that was mentioned before. This is the Spiria case, where Sweden made an appeal to the Court of Justice and brought an appeal from a ruling of the General Court. So what happened here is that Mr. and Mrs. Spiria requested, in a very dramatic situation, for access to a set of documents exchanged between the European Commission and Germany in the context of EU pilot proceedings. What happened is that the son of Mr. and Mrs. Spiria was in a hospital in Germany when he was operated, and he died. And according to Mr. and Mrs. Spiria, this event was due to some bad procedures that was applied in the hospital, and it could happen because Germany did not apply properly the regulation, European regulation on advanced therapy medicinal products. And so the Commission, Mr. and Mrs. Spiria made a complaint to the Commission. The Commission started to investigate on it and exchanged some and opened an EU pilot procedure and exchanged in this context a few documents, few mails with Germany. And Mr. and Mrs. Spiria asked for the access to these documents. Commission refused, and General Court upheld the decision of the Commission, and the Court of Justice also confirmed the solution. What is EU pilot, and this is maybe why this ruling is so annoying, maybe for certain countries like Sweden, is that EU pilot procedure is not actually an infringement procedure. It's a procedure that was provided for by the general document of the Commission, a communication for the Commission. It's a procedure which is aimed at cooperation between Member States and the Commission, cooperation concerning the application of the EU law. So whenever the Commission considers that the Member State have some problems with application of certain directives or regulation, it can just try to discuss trying to find the solution to the problem, and measure the scope of the problem and make a follow-up, and so on and so forth. So this is actually a very soft procedure. So why should we think that it's an infringement proceeding? But according to the Court of Justice, actually this proceeding is aimed at resolving problems connected with infringement of EU law, and for this reason it should be actually treated in the same way as infringement proceedings. So in this ruling, the Commission confirmed that documents in the file of a EU pilot procedure should be protected in the same way like documents in a file of infringement proceedings, and so they are actually protected by the general presumption of confidentiality. And it was here that the General Court applied this, the Court of Justice applied this general presumption of confidentiality to only 2 documents that was in the file. But according to the Court, what makes the category of documents is not only the quantity of documents, but also the quality of documents. So this appreciation, this assessment has to be done also from this qualitative point of view. Next case is Client Earth against Commission, a case that concerns request for access to document concerning the conformity of member state legislation with the EU environmental law, and that request was then just limited. Well, the Commission has given access to certain documents. What happened here is that the Commission requested a study to a body which was independent. It was not made by the services of the Commission. And the study concerning the level of application of the transposition of the different acts of in EU environmental law, country by country, member state by member state, and regulation directive by directive. And here the problem that arose before the Court of Justice and the General Court was whether actually this kind of study is covered by the concept of investigation. Can we talk about investigation? Can we invoke Article 4, Paragraph 2, the protection of investigation in such a case? Because the Commission was not actually investigating anything. It was just trying to figure out what was the state of application of transposition of the EU law. However, how to say, according to the Court of Justice, everything that touches upon the observance of the legal order, the observance of the EU law, actually is an investigation, and the Court of Justice considered that the concept of investigation should be also applied in this context. And as we were here in the investigation context, the General Court and the Court of Justice confirmed the refusal of access to the part of those documents. However, here there was a slight discrepancy between the Court of Justice and the General Court. The General Court actually affirmed the application of the general presumption of confidentiality to all the documents in the file. And the Court of Justice was more precise because it found out that it considered that certain documents were actually not added, did not belong to a file of an ongoing administrative or judicial proceeding. So therefore, the Commission could not apply the general presumption to those documents, but it needed to examine them on a case-by-case basis. So that's a very tiny limitation to the scope of application of this presumption. And the next case is case France against Richter. That's a very interesting case because it concerned a different type of proceedings. That was the request for access to document, very specific document, a detailed opinion issued by the Commission in accordance with Directive 98/34 and concerning French notification under Article 8 of this directive. So this directive is the directive on the provision of information in the field of technical standard and regulation, and it creates a procedure which is a notification procedure. It's more or less like with state aids. Member states are obliged to notify to the Commission norms or technical provisions that will be applicable. They are still they're not yet applicable, but they will be applied soon. So there is an ex ante control of this type of technical standards and regulation, and other member states and the Commission can make comments on it, and especially the Commission can issue a detailed opinion whenever it finds that the envisaged means may create obstacles to the free movement of goods. And in such a case, a member state has to suspend the application of this rule. It has to wait, so there's a standstill period, and until the problems concerning the creation of obstacles to free movement are solved. So here, Mr. Schichter actually asked for the access to this kind of document, so this detailed opinion of a Commission. Commission refused the access on the basis of Article 4, Paragraph 2, so it concerned that this is an ongoing investigation. And Commission considered that, well, this procedure may potentially result in infringement proceedings, so we are actually in the case of infringement proceedings. And the General Court first didn't absolutely share this opinion. The General Court annulled the decision of the Commission. It considered that this decision violated Article 4, Paragraph 2. And it considered actually that this kind of opinion did not come within the scope of an investigation procedure. What the court actually considered, General Court, is that here, but the investigation is, we can only talk about investigation when we are investigating an existing infringement. And when we are in a situation that infringement does not exist because the rules are not yet applied, when we are doing an ex ante check, well, then we cannot talk about an investigation. And that was the reason why the General Court has annulled this decision. However, the Court of Justice took a different point on it. It confirmed the annulment, but it applied a different reasoning. The Court of Justice applied an extensive interpretation of the notion of investigation, and it considered that a structured and formalized Commission procedure that has the purpose of collecting and analyzing information in order to enable the Commission to take a position on a certain issue concerning the application of EU law actually is an investigation. However, the Court of Justice took into account the specificity of the directive, and it considered that actually this directive establishes, attention, a requirement of transparency because the system that is provided for by this directive allows the operators, economic operators, to see what are the regulations that are going to be applicable, and actually the operators, they need to know what are going to be the rules in order to anticipate the adoption of this new regulation and comply with them. So for that reason, according to the court, this kind of opinion that contained every appreciation of possible problems concerning the free movement of goods should be accessible to public. So that's a very interesting ruling, I think, because it concerned this very unusual type of administrative proceedings. Let's turn now to access to documents relating to decision-making process. And here again, well, we have the two principles that are fighting, the transparency versus effective decision-making process. And again, we're going to have to ask the court was faced with this general presumption of confidentiality. It had to define the scope of application of this presumption. And what was also interesting in the case law recently decided is the highly sensitive and contentious decision-making processes. This is, of course, Philip Morris case. So let's turn first very quickly to the ruling of 13 November of 2015 of the General Court in cases T 424/14 and 425/14 client Earth against Commission. Well, I'm going to be brief because this ruling has been, there's an appeal pending. There was appeal pending before the Grand Chamber, and in 1 week we're going to have the opinion of the Advocate General in this case. We're going to learn a little bit more about the proposal that are given to for the solution to the Court of Justice, so on the 28th of November. And but this case is very interesting because it actually applies for the first time the general presumption of confidentiality in the new context, meaning in the context of Article 4, Paragraph 3. And here there was a request made by Client Earth for access to draft impact assessment and the opinion of impact assessment board that were drawn up in the context of preparation and negotiation of the Commission legislative proposals relating to, on one hand, inspection and surveillance in respect of environmental matters, and on the other hand, the access to justice in environmental matters. And because this negotiation process was very contentious, and the Commission has already made a legislative proposal in 2003 and withdrawn it, and that was a very delicate negotiation, so the Commission refused the access to those documents because of the ongoing decision-making process. And here we are really on the border of the legislative procedure and negotiation before the starting of the legislative procedure. So Commission is not a legislator, but the legislative initiatives comes from the Commission, so that's why we are on this borderline case. And the General Court actually, after a long maturation, I'd say, because there's very, very long ruling, came to the conclusion that the general presumption of confidentiality was actually applicable within the context of Article 4, Paragraph 3, so in the context of an ongoing decision-making process. And as I said, it is this ruling is express, in my opinion, the doubts of the General Court as far as the application of this presumption is concerned in this new context. However, slowly but surely, the reasoning made by the General Court led them to the conclusion that yes, this presumption could be applied in this new context. And here again, the General Court repeated that it's both a qualitative and quantitative criterion that determines whether a general presumption of refusal of access may apply or not. And here we have just 3 documents in each of batches that were requested. And finally, the General Court also set out the time limit of the application of the presumption, and it said that this general presumption may apply for as long as the Commission has not made a decision regarding a potential policy proposal, so either adopt it or abandon it. So we will see what's going to happen. It will be fixed in a few months, and in a few days we're going to learn something from the opinion of the Advocate General. And yet, now, it's just a suspense. So let's turn to Philip Morris. It's actually a case not about decision-making process, but about the protection of legal advice and judicial proceedings. However, the documents that were requested here by Philip Morris actually related to the decision-making process. So Philip Morris requested for an access to documents drawn up in the context of the preparatory works leading to the adoption of the new tobacco product directive. It's a very, very contentious text. This is a new directive that provides for new rules on labeling and packaging of cigarettes. It's a plain packaging, and also phasing out of certain flavored tobacco products. And this act was opposed by the tobacco industry. That's natural. But there was also an opposition against this act from the side of certain member states, namely Poland and also Romania. And this context create actually very nervous and tense atmosphere around the request for access that was filed by Philip Morris. First, the Commission, trying to delay the response, and the request was made in the end of January 2014, and and the answer was actually given only in July. And within this time, Poland has filed for the annulment of its action for the annulment of the directive. So the documents that was asked by Philip Morris were really the Commission was in a very difficult position. The Commission actually has given access to a number of documents to Philip Morris, but it protected certain documents that concerned, namely, the choice of the legal basis for this new directive and other issues that were actually connected with litigation, ongoing litigation against Poland, but also against Philip Morris, because Philip Morris also filed an action in UK that was aimed at invalidating a certain provision of this directive. And you can imagine that in this context, the Commission didn't want to give access to certain documents to Philip Morris. And General Court generally, uphold the point of view of the Commission. Commission refused as I said, it gave access to certain documents, but it also refused the access to other documents on the grounds of Article 4, Paragraph 1, so the protection of privacy, and then protection of legal advice and judicial proceedings, and also protection of the decision-making process. And General Court, I would say, largely upheld the views of the Commission, but I can say I was a witness of this ruling, because it was a ruling of the 8th Chamber. I was working for the 8th Chamber, and I was working also with Mr. Vetter, who was a judge rapporteur in this case, and this was a Swedish judge, and he was really fighting against him in this case. But actually the reasons for the refusal of access were really clear. And this is why the Court of Justice, the General Court, upheld the decision of the Commission and only annulled one decision and only have given access to 3 paragraphs of one document. And before doing this, the General Court examined in every detail, all the requested documents. I mean, all the documents requested by the company, by Philip Morris. And I have resumed 3 rulings of the General Court here in this one slide. It makes a lot of text. But I think that this was rather clear that in the situation where you have an ongoing litigation, the protection of legal advice and protection of court proceedings will apply to the requested document. And the General Court, as I said, really made a very detailed analysis of the requested document to be sure that this document could actually the disclosure of this document could be harmful for the Commission. And what is, I think, the most important point in this ruling, what gives a little bit of the taste of what happened in the chamber, what happened in the head and in the heart of Mr. Vetter, is the first point here is that, okay, regulation, access to document regulation imposes in principle an obligation to disclose the opinion of institutions' legal service relating to a legislative process. This is something that stems from the case law. But then it says, however, it does not preclude a refusal on account of the protection of legal advice to disclose a specific legal opinion given in the context of a legislative process, but being of a particular sensitive nature. And then it continues saying that unlike in case Sweden and Turkey versus Council, here we are in presence of 2 ongoing and pending court proceedings concerning the annulment of the directive. So this is why this refusal was justified. And here this is the point. I think it's really the hand of Mr. Vetter. It was not inconceivable that there was a not purely hypothetical likelihood that the Commission's ability to defend itself on an equal footing when intervening in this action may be compromised. So you can see that this is really like, it's not really inconceivable that the interests of the Commission could be harmed. So the Court goes really far in this weighting of interests of the Commission and the principle of transparency. And it followed, as far as court proceedings are concerned, the court said, well, it's common ground that requested documents were not pleadings and that they were not drawn up for the purpose of the court proceedings, but they were drawn years before. However, the presumption that was established in Sweden against API could be applicable here, could apply here, because the sense of this presumption is actually the protection of the principle of equality of arms, which is a corollary of the very concept of a fair trial. So I think that here what the Court of Justice, what the General Court did, is that it went as far as it could in respecting both the principle of transparency and then the need for the protection of the judicial proceedings. And let's turn to the third part of my presentation, documents, well, access, case law concerning access to documents containing environmental information. And here, the cases I'm going to talk about concern basically the scope of the concept of emissions into environment and information on emissions into environment. And I found a very interesting example of a coordinated answer to basically the same legal question, which is actually the scope of the concept of emissions to environment and information relating to emissions to environment. And the Court of Justice has two different cases in the dock. One case concerned an appeal brought by a party that requested an access for documents, and the other one was the case that was a preliminary question that was asked by a national court from the Netherlands, and the Court of Justice joined those cases to a certain point, but actually adopted two different decisions, but on the same day, on the 23rd November of 2016. And the first case concerned access to documents under the regulation to several documents prepared by Germany, acting as a rapporteur member state, and in a proceedings relating to the authorization for the placing of glyphosate on the market under Directive 91/414. This directive since then has been replaced by another directive, but it's a secondary issue. What is more important here is that refusal to access to this document was motivated by the opposition of Germany. So Germany has collected the data, collected information concerning the placing of glyphosate on the market, and draw some conclusions from it and transferred everything to the Commission. And the Commission, when it was faced with the request for documents, consulted Germany about the disclosure, and Germany actually gave its approval for the disclosure of those documents, and it only opposed to the disclosure of one document, and it invoked Article 4, Paragraph 2 of the regulation and protection of commercial interests and intellectual property of a company that was placing glyphosate on the market. And because Germany based that its opposition on this provision, we are actually directly here in the situation that is regulated by Article 4, Paragraph 1 of ARAS regulation. And what this provision says, in essence, is that whenever there is a request for access to documents in concerning an environmental information, then there's an opposition that is raised to this request based on Article 4, Paragraph 2, it should be considered that there is an overriding public interest in the disclosure of this document whenever the information requested concern emission to environment. So, in other words, and I hope more simply, whenever the requested information concern emission to environment, access to the document that contains this information should be granted, even though the same document can contain data protected by Article 4, Paragraph 2. So in this case, what was actually the key issue was not whether the document contained any data protected by Article 4, Paragraph 2, but whether actually the information that was in this data, in this document, related to the emission to environment. And here the General Court has given, I'd say, a generous interpretation of Article 6, Paragraph 1 of ours regulation, because it considered that it is enough that the information requested relate in a sufficiently direct manner to emissions to the environment. So somehow it stretched a little bit the scope of application of Article 6. However, the Court of Justice did not share this view. The Court of Justice first, well, the reasoning of the Court of Justice was divided into 4 parts. And in the beginning, the Court of Justice confirmed what the General Court said. It said that the concept of information which relates to emissions into environment must not be interpreted strictly. So here the Court of Justice actually confirmed the reasoning of the General Court. It said also that there is nothing in the Ars regulation to support the view that the concept of emission to environment must be limited to emission emanating from certain particular industrial installations like factories or plants. It's actually normal in the context of placing on the market of plant protection products. That was the case of glyphosate. Because this kind of products are actually directly, can go directly to the soil or the water, so there's no need for any particular installation for those products to get into, to be emitted to the environment. And thirdly, the Court of Justice considered that information which relates to emission to environment is not restricted to actual emissions, but it can only apply to foreseeable emissions. But on the 4th point, it did not accept what the General Court has said, and it did not actually accept this little stretching of the scope of application of Article 6, and it just said that Article 6 should be interpreted as it is. So the information which relates to emission to environment should be interpreted as information which relates directly to emission into the environment, and not the information which is like a sufficiently direct link to this kind of emissions. So on this point, the Court of Justice decided that the General Court erred in law and annulled its ruling. And I'm sure I was not wrong. This is the good title of the ruling. It was dictating Greenpeace, but I don't know why I was just I had in my head that that was Client Earth who brought this proceedings to the Court of Justice. Maybe because Client Earth is actually the best client of the General Court. I'm going to finish with it because biocrop science doesn't say anything else than what I've just said. What we need to do is to read biocrop science together with the Greenpeace ruling, and they both give actually the interpretation of the notion of the concept of emission to environment and information emission to environment. And the last case, the last slide concern Client Earth and access to documents containing personal data. And here, I don't know, maybe we will leave it for the discussion if there are any questions to this case. I think what I can leave you with is, anyway, an exhaustive presentation, I think, of actual and current developments of existing in the case law concerning access to documents. And thank you.